Good morning, everyone. We're glad to be here today. As part of the NDI Virtual Expo, we've got a really great presentation lined up for you today on patent litigation in the medical device space. The presentation will provide an overview of patent litigation in Europe and in Israel, how it works, and strategies for success. We'll provide you with some take-homes that we hope will be useful for you in the medical device space. I'm Asa Kling, the chair of IP practice at Naschitz Amir. Naschitz Amir is one of Israel's largest and prestigious full-service law firms with international and domestic practice that embraces virtually the entire spectrum of civil matters. We have here today with us our friends from the intellectual property team of the renowned Hogan Lovells International Law Firm, having 2,400 lawyers in more than 40 offices around the world. We have Miriam Gund, a partner from the Hogan Lovells Düsseldorf office, Ruud van der Walden, a partner of the Amsterdam Hogan Lovells office, and Stella Wong, counsel at the London Hogan Lovells office. Without further ado, I'll start my presentation about Israel, about patent litigation in Israel, what it is about and how it works. But before jumping in, just to make sure that all of us are on the same page, just some basics so we have an intelligent conversation. What is the scope of patent protection? One needs to understand that a product may be protected by various patent rights. A stent for being installed in the blood vessel may be protected by proprietary rights pertaining to its material, as one aspect of the product, and on another to its actual function as another aspect of the product. Those various aspects might, in certain circumstances, be subject matter of one patent or of different various patents. One also needs to understand that there's a basic difference between protecting a product and protecting a process being how the product actually works. Mostly, we will want to obtain protection for both product and process. This is not always available, but we need to keep that in mind. When we talk about infringement, meaning whether someone is infringing upon our patent rights, we need also to question how are those rights infringed. Is that a literal infringement per the language of the claims? For those of you who've seen patent documents, a patent ends with a list of claims which outline the legal protection the patent provides. Very seldom it is the case that an infringement falls foursquare of on the language of the claims. And then we need to exercise a practice of checking the equivalence of the infringing product on the one hand and the essence of the invention as it arises from the claims as interpreted in view of the description of the patent. Meaning the identification of there being an infringement is not a very simple exercise. Then we need also to consider against whom are we going to enforce our patent rights? Against any user of the patented invention, or, and that is mostly the case, actually against competitors. We mostly will not want to sue our potential clients. We will want to sue and prevent our competitors from approaching and selling to our clients. But then we need to identify that infringing operation, the infringing use of our invention as described in the patent by the certain specific person against whom we want to enforce. There are several issues that we need also not to confuse when we speak about patent litigation. There are also other intellectual property rights. There are design rights, copyrights, and trademarks as well. In the US, the issue of design rights and utility patents, meaning inventions that are functional, both of them are called patents. In the US, it's design patents and utility patents. Whereas in Israel, as in the UK and other places, those are very separate, discernible rights, which are enforced separately. So our product might be protected in addition to a patent, might be protected by also other intellectual property rights, by the way it looks, and that would be its design, by the way it is described in our information, in our kit that explains how to use our medical device. We will have copyright protection on the text that we've written. And of course, there's the logo and trademark that we can also protect. These are separate rights, and we need not to confuse them with the patent rights. We need also to remember that there are also other proprietary rights. A patent is owned by a person and who wants to protect her rights. But one may have also additional property rights in the data underlying in the product or the service that I'm providing. This is in many times the case when we talk about digital health services, where one, for instance, uses big data information and manipulation to learn lessons and methods. And then arises the question, who owns that data? Is that the medical institution that provided the data, or is it the actual person whose data is being used? And there enter into play also issues of privacy, which also affect the issues of ownership. So we need to remember that there are also other players in the field of ownership in the scheme of product in the medical device digital health space, in addition to the patent right, where the patent right, as we just said, can protect both the product, the service, and the method at hand. You need also to remember that receiving a patent is not an authorization, an absolute authorization to use it in the market. One needs to remember that there are also competitive limitations to be taken into account. Although we like to call a patent right a patent monopoly, it is not always, does not always provide monopolistic rights, but at times we need also to consider the limitations of anti-competitive practices that might arise from using such an exclusive, unique right. And before we delve into how we litigate actually in Israel, we need to answer the question, why are we talking separately here in this session about Israel in Europe and other territories? Because always remember that a patent is a territorial right which needs to be enforced separately in different countries. If I want to enforce my rights in Israel, I need to apply to a court in Israel. If I want to enforce my rights in the UK or in Germany or in Holland, I need to have a patent in those territories and take action. About that, about the other territories, my colleagues from Hogan Lovells will be discussing a bit in a few minutes. I will focus about the Israel patent litigation process. We can roughly divide it into 4 parts. The first three are actions that can be taken in the court of law. In Israel, it's the district court, and actions that can be taken before the patent commissioner. When I want to enforce my rights, I go to court, and I need to persuade the judge that my patent, as I received it from the patent commissioner, is being indeed infringed. For that purpose, I file a lawsuit. And in the lawsuit, I apply for obtaining an injunction, meaning restraining the other party from using my invention, to which I did not grant any permission, I did not grant any license. And I want to collect also damages at the end of the day, but to that end, I need to know how much he sold, at which price, and for that end, I can also apply for receiving reports and accounts regarding the infringing product sales. But I don't want to wait to see the result of the lawsuit, which can take quite a considerable time. And in many cases, if I wait, I lose the market. And I want to stop the competition outright. To that end, I can apply for preliminary or interim reliefs and request the court to provide for a temporary injunction. And also, because I want to manage the lawsuit, I might need to collect evidence from the infringing party. And I can request the court to collect evidence from computers, from data systems, from manufacturing plants of the competitor, so as to prevent the destruction of evidence, which, if destructed, I might be in a difficult position to prove my case later in the day. But we need to remember, as I said, this is a territorial issue when I apply for a court in Israel, but the courts do understand that in the intellectual property field, the international rights are important. I want to stop operations also in other countries, in other markets. To that end, I can try and apply for a blocking order outside of Israel. That is a very rare relief to be received, but that is also an option that can be considered in a court in Israel. If I'm on the other end of the story, at the receiving end, I'm being suspected to be an infringer, and I know that my competitor, who is a patent owner, might be considering suing me, I can run to court and apply also for a declaratory relief by filing a motion for the court to declare that my product that I need to present and explain does not infringe a granted patent. But then that is a dangerous exercise to do, because that might draw the attention of a patent owner who might not be considering actually going to court. But that is an option, and these means of filing a lawsuit in court and enjoying interim relief should be considered when on the basis of what the other party might do, and filing for declaratory motion is one such option. In parallel to the options in court, one needs to understand that the issue of validity of the patent may be assailed also before the patent commissioner. I will just remind you that the patent commissioner is the authority which granted the patent in the first place. But a patent can be, in Israel, can be revoked anytime during its life, its 20 years life. So if I know that someone is going to assert her rights against me as a defensive action, I might run to the patent commissioner and file against the validity of a patent. I just note that in Israel, during an infringement case that has been initiated in court, I can't automatically initiate validity proceedings before the patent commissioner in parallel to the court proceedings without the court's permission. So you see, it's already becoming a very tactical situation with many parameters to be considered. But one of the main parameters to be considered is the timeline. Just to put all of us on the same page, in Israel, if I run to court, I know that someone is infringing my rights, I can file an ex parte preliminary relief request, and in theoretically, in most cases, I can receive the injunction within a few days, within a matter of 1 week, but it is very rare to receive such relief. In most cases, I will file initially already an in parte with both parties application for preliminary relief, because the court will, in most cases, divert the motion to the response of the other party. And an inter parte preliminary relief motion would be resolved within 2 to 3 months in average. And it is a good idea to file for preliminary relief because a lawsuit, as you can see on this slide, in Israel, a patent infringement case in the better chances would take 2 to 3 years to be resolved. So if you manage the case for 2 to 3 years, unless you have already a dominant position in the market, you'll be losing the market during that time without having a preliminary injunction in place. And then, of course, each party has a right to appeal to the Supreme Court from the District Court in Israel, and such an appeal would, on average, take 1 to 2 years. I presented here a regular timeline. Of course, things can go back and forth, back to appeal, and then back to the lower court. And of course, the preliminary relief motion can also be appealed to the Supreme Court. So time is of essence, and time is the main issue to be considered. But if we want the process to be efficient, we need to prepare. We need to prepare properly for patent litigation. How do we prepare for that? First of all, we need to draft a patent application with thinking of what competitors might be doing down the line. We don't know that for sure, and it's an exercise of prophecy, which is very difficult. To that end, it might be a good idea to keep a patent application alive, meaning that it should be pending and file for divisional applications. And if we anticipate that we might be considering litigating for infringement in some time in the future. And of course, we need to collect, if we are to apply for preliminary injunctions, we need to collect evidence of infringement before we apply to court. Without prima facie good evidence, we will not receive preliminary injunction, although it does not have to be definitive evidence, but a prima facie case needs to be made for the preliminary relief stage. Again, if we are on the receiving side, if we might be suspected of infringement, we might want to build up a patent portfolio as a defense against litigation, as a Cold War balance. And in any case, we need to, when we want to consider litigation, we need to consider cross-border considerations. If we own patents in other territories, we will want to consider where to start, where would be having a preliminary relief the most effective measure, the most effective litigation system. And the Israeli system is working, is effective, although in many cases the litigation happens in other territories. And for that matter, without further ado, I will hand over the continuation of the discussion with also additional cross-border considerations to my friends from the team of Hogan Levert. Thank you very much. I'll be available later on for questions and answers.